Major Trent Bradford is an assistant professor of law at the United States Air Force Academy, where he is the director of cyber programs for the Law, Technology, and Warfare Research Cell. He holds a Juris Doctorate from Brigham Young University's J. Reuben Clark Law School and an LLM in Space, Cyber, and Telecommunications Law from the University of Nebraska at Lincoln. Over to you, Major Bradford.
I hear more clapping than I see people out there. That's really something. I like these kinds of crowds. They're great. All right. Legal ethics is a critical component of the legal profession that governs the behavior and conduct of lawyers and other legal professionals. Lawyers are entrusted with the responsibility of upholding the law and promoting justice, and they are expected to act in accordance with the highest ethical standards. The legal ethics framework comprises a set of rules and principles that guide lawyers' professional conduct. These rules cover a wide range of issues, including confidentiality, conflicts of interest, competence, communication, and integrity. Lawyers who violate these ethical standards can face disciplinary actions, including suspension, disbarment, or other sanctions. Moreover, unethical conduct can also have severe consequences for clients, for the legal profession, and society as a whole. This legal ethics briefing aims to provide an overview of the key ethical considerations that lawyers and legal professionals need to keep in mind while practicing law. The briefing will cover the ethical rules and principles governing the legal profession, highlight common ethical dilemmas that lawyers face, and provide practical guidance for maintaining the highest ethical standards in legal practice. And here's the common disclaimer. These are my views alone. I'm not speaking on behalf of the Department of Defense. So with that, I've already been introduced. I teach here at the Academy. It's my first year and I love it. I love teaching. Don't love grading as much, but I love teaching. But since, again, I was already introduced, we'll move right on. And here's what we're going to cover today. First off, transactions with people other than clients as kind of an important piece, just what I chose to talk about. Then we'll move on to technology-related duties, data breach ethics, and professional responsibilities when working remotely. So first, transactions with other persons. It's a short rule, only 4 subparts. We'll talk about each one and start with truthfulness and statements to others. So a lawyer generally has no affirmative duty to inform an opposing party of relevant facts. However, we are required to be truthful, and we should not affirm a statement that we know to be false. Also, partially true but misleading statements or omissions that are the equivalent of an affirmative false statement may also be considered misrepresentations. So we need to avoid all of those things, even though, once again, we don't have a duty to affirmative duty to inform an opposing party of relevant facts. So that's where the line is. Now, we're not allowed to assist a client in conduct that we know to be criminal or fraudulent. I had an interesting experience with a client that I had who told me, hey, I have this witness who can help us out. We were in kind of dire straits as far as the case against us went, but he said, I have a witness who can explain that this is what happened and that will help us out. And I was excited about that. So I interviewed the witness, I brought him in, and sure enough, this was a fantastic witness. He presented all right, but he was a direct witness to some events that really helped our case. But he seemed a little bit too perfect. So I asked him a few more questions. I talked to him a little bit more, and I started to realize that this particular witness was going to say whatever he thought I needed. In fact, eventually, he said as much. Hey, whatever else you need me to say, I can say. And I realized this is a witness for hire. This is a friend of my client, and he fully intends to perjure himself. And so I had to have a talk with my client and tell him why we were not going to call that witness. But does that really bring up these ethical considerations? Because I wouldn't be making a false statement. And this comes from comment 3, where we can't assist a client in conduct that we know to be criminal or fraudulent. But my client wouldn't be the one committing perjury. So does it really bring up these ethical considerations? Well, I think so, because I also knew that aiding and abetting in committing perjury, solicitation to commit perjury, conspiracy to commit perjury would all be things that my client apparently wanted to do. And so I was not going to aid him in those things. We might need to keep an eye on jurisdiction when we consider not assisting clients in things that we know to be criminal or fraudulent, because especially when it comes to space law, there are a lot of international implications. And so we need to think about, are there other rules that we need to look at to make sure that wherever it is we're operating, whoever it is we're operating with, we're complying with the relevant laws. Things that are exciting, like resource extraction, where we, the United States, have laws that seem to fly in the face of countries who have signed the Moon Agreement. So keep jurisdiction in mind when not helping clients to do things that violate the law. So on to rule 4.2, communication with persons represented by counsel. If you know a person to be represented, you can't communicate with her about that matter. As simple as that. Looking at some of the comments to this rule, it applies to any communication, comments 2 and 4, any communication concerning the subject of the representation, but it does not apply to matters outside of the representation. It applies even if that's the person who initiated the contact or if the person requested the contact. We are not allowed to talk with them about the matter just because they come to us if we know they're represented. It's the attorney who needs to say it's okay, unless we have some other legal reason to talk to that person or some other a court order or something of that nature. Now, when it's an organization that is represented instead of a person, then there are a couple of things that dictate who it is that we cannot talk to as a lawyer. Anyone who supervises or directly works with the attorney, supervises the attorney, consults with them regularly regarding that matter, will be someone that we're not supposed to talk to. We need to go to the attorney. Anyone who has authority to obligate the organization with regard to the matter of our representation is someone that we can't talk to. And then anyone whose act or omission could be imputed to that organization, again, is someone that we are not allowed to talk to. So keep in mind that applies even if they come to you. If you know they're represented and they come to you, you need to say, hold on, and get permission from the attorney before you talk to them. So then, moving on to rule 4.3. We can't even imply or feign disinterest when we're talking to someone who is unrepresented. Obviously, we can't state that we're disinterested, but we can't even really let them believe that. In fact, we have an obligation to correct any misunderstanding that may come up. With one place that this comes up in Air Force practice is with unrepresented crime victims. With the Victims Counsel program, that is less common, but it still happens. Having spent several years as a senior prosecutor, I did see a number of cases where we had crime victims who were not represented. And at least in my experience, it seems that assault victims in particular sometimes see a prosecutor as their lawyer. And so we just need to make sure not only that we don't lead them astray in that way, but that if we notice that they may think that way, we need to make sure and make that correction. So that's rule 4.3. And then the final piece of this one, rule 4.4, third-party rights, respect for the rights of third people. While we owe a duty to our client, we are not to violate the rights of other people. We shouldn't do anything solely to embarrass, delay, or burden third parties. Now, in part B, the obligation in this case is to notify the sender. We're going to talk about this one more when we get into the technology piece. But when you receive a document, an electronic document or something of that nature, and you know or have reason to know that it wasn't meant to be sent to you, what is your obligation? Is it not to read it? Is it to destroy it? Well, that might depend on your jurisdiction. But as far as the model rules are concerned, the obligation is to notify the sender. That's interesting, and it will have a further implementation later. But this is a know or should have known rule. So if you know it was accidental, that one's easy. But if really it's something that you should have looked into a bit or should have realized, then you're still going to be held accountable for that. So keep that in mind. Now, I do want to go briefly back Oh. Before I do. There we are. Comment one. Once again, we have a duty to our clients. That doesn't mean that we can disregard the rights of third persons. That also applies when we receive some document. If there are specific rights attached to that document, and that's going to be case by case, then we need to keep in mind this piece of the rule as well. So before wrapping up, I do want to go back to the truthfulness piece before we move on. There we go. Because I have my own disclosure. While I haven't made a false statement per se, and my failure to disclose is not criminal in nature, still I do need to get this off of my chest. That well-scripted intro, I didn't write. It was written by artificial intelligence. It was ChatGPT. I said, write an intro to an ethics brief, and that's what ChatGPT gave me. And in further disclosure, that wasn't even my idea. Our Law, Technology, and Warfare Research Cell Director, Colonel Timothy Goins, had ChatGPT write his intro and conclusion to the last ethics brief he gave. So that's my disclosure, and I think it's a good time then to go on to technology and related obligations. ChatGPT wrote that, every word. I read it word for word, yes. And the flyover we also arranged as technology to just make everybody get their minds into technology. So we may have a few more as we go on. As we all know, the Air Force is a little off when we try to time our flyovers. I'm just kidding. I'm sorry. All right. So technology and related duties. Here on the left are some of the duties that we're going to talk about specifically, and on the right are the rules associated with those duties. So we'll touch on each one of these. Most of us are familiar, of course, with the obligation to keep pace with the changes in the law and to comply with CLE requirements, which is why there's so many hundreds of us here in these seats today. Now, we also have a specific obligation to keep appraised of the benefits and the risks associated with relevant technology. And even though this kind of seems like a new rule, we still talk about it as if it's new. It's actually over a decade old now. This duty of competence related to technology was added in 2012. So, a lawyer shall provide competent representation. Part of that is to maintain the requisite knowledge and skill. A lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So, to be competent, that doesn't mean that we have to be a specialist. There are fields of law. In fact, most fields of law have a lot of depth to them. None of us as lawyers can memorize all of the law, either generally or in a specific field. And these rules don't require that. A brand new practitioner can be considered competent. You just have to do the work. You just have to do your homework. In a field you don't specialize in, you can still be considered competent and bring yourself up to speed. But we do have an obligation to make sure that we recognize when it's beyond our capabilities, when we need to reach out to associate with an attorney who specifically has experience or knowledge in that particular field, or when we need to do more research. All right. So most of us are already aware of this, but it bears repeating. You cannot disclose information relating to the representation of a client unless that client gives informed consent. So what exactly is informed consent? According to ABA Rule 1.0E, informed consent denotes agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks and reasonably available alternatives to the person's course of conduct. So what that means is it's not enough just to advise them on your proposed course of conduct. We have to also advise them of the reasonably available alternatives. And that's the key to the informed piece of this. Our clients can't truly make educated and informed decisions if they don't know the reasonable alternatives. In Air Force criminal practice, it's very common when a client is offered an Article 15 for that client to accept the Article 15. Even if the client may have a case that they could be found not guilty had they turned it down and gone to a court martial. It's very common to accept an Article 15 for a few reasons. The risk of going to trial is so high, you may have a federal conviction on your record forever. You may get kicked out of the Air Force, where with an Article 15, maybe you could stick around. You may get jail time. Lots of risks associated with turning down an Article 15. And so it's common for people to accept those. And by implication, it might also be common to advise people to accept those. But we as attorneys have an obligation not just to say, here's why you should accept it, this is what I recommend you do, but to give them all of the facts, to give them the risks and the possible rewards, and to advise them accordingly so they can make that decision. I had a client who was so adamant that it was a matter of honor. He didn't want to turn down an Article 15. I probably could have beat him into doing it, told him all of the reasons why it was dumb to turn it down, and essentially taken the choice away. But our obligation isn't to do that. We can advise very strongly. We can advise and give them every reason to want to follow our advice, but we do owe them the duty to give them the option. So this particular client didn't want to accept the Article 15. It worked out okay because even though he went to trial, he was acquitted, but that was his choice to make. He understood the risks and he made the choice to accept those risks. And that's what our duty is to make sure that our clients understand the risks of giving a CLE briefing to 5 individuals while jets are flying over. I'm glad those jets are here. I'm boring myself. Some of you are still awake. That's wonderful. It's probably because of the jets. So, yeah, just keep circling, please. Keep circling. So I brought up part C here. This is a fundamental principle of the attorney-client relationship. Without this confidentiality and privilege, clients won't have trust in their attorneys. And this trust is essential to our work, because if clients can't communicate with us, frankly, then we can't represent those individuals. And I not only believe this to be true, I know it to be true. Another client story, one client I'll never forget, and I won't go into detail, and obviously I won't give a name, but I'll never forget this client because it took so long for this client to open up to me. Typically, it seems like Air Force people in particular, they're very open and very easy to trust their attorneys. But not this one. He would give me a set of facts. I would start to dig a little bit. And then I would have to confront him with some facts that I had uncovered that showed that he was lying to me. One moment, please. Few moments, please. All right. And this didn't just happen once, it happened 3 or 4 times where, okay, I'm sorry, I'll be straight with you. Here's my story. And then 3 moments, please. So this happened a few different times. And I sat my client down and I told him, here's exactly what's going to happen. Here's what happens if I don't know what's going on. Here's what happens if I do know what's going on. There will be these motions. Government will probably argue this. Here's what the trial is going to look like. That trial was delayed for a while. But I remember during trial, during one of the breaks, sitting down in a room and my client saying, Captain Bradford, everything is happening exactly like you told me it would months ago. And I was like, really? You'd think I do this for a living. But we need to have that confidentiality. We need clients to be able to trust us. If we are disclosing things, whether it's on purpose or not on purpose, then our clients are not going to be able to trust us. Now, obviously, we can't disclose things on purpose, but we also have to take reasonable efforts to prevent any kind of unauthorized disclosure. There are times when disclosure is impliedly authorized, such as when it's necessary to carry out the representation. A lot of us work in offices or firms, and it may be appropriate to talk to other attorneys in the office or the firm to facilitate the representation. The client can ask us not to do that, in which case we should observe the client's wishes. But generally, if it's not discussed, that's something that's going to be okay. You can admit a fact that can't be properly disputed or make disclosures that facilitate achieving the client's end goals. So those kinds of things that help with the representation are impliedly authorized. But the client can ask us not to do those things, and we should do that. There's a whole list of permitted disclosures under paragraph B. Feel free to look them up, but we're going to skip them. We're going to focus on paragraph C. I clicked a little too early. It's right there, paragraph C. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information relating to the representation. So in order to explore what reasonable efforts really are, we need to dive deeper into the comments on confidentiality. So comment 18 of paragraph C, a lawyer is required, there's a lot in here. This is a completely crammed paragraph. A lawyer has to act competently, right? Not just your best efforts if your best efforts aren't competent, but act competently. Make sure we are competent. In doing this, safeguarding information relating to the representation of the client against, first, unauthorized access by third parties. That's where the bad guy is trying to get at you, and you haven't necessarily done anything wrong. You have to protect against these bad guys who might want to get this information. We'll talk more about that. Talk a lot more about that. But also we have this inadvertent or unauthorized disclosure, which is not just by us as lawyers, but we're also held accountable for other lawyers under our supervision or other people in our offices. It includes those that we supervise, as any breach of confidentiality on the part of our staff or our paralegals will flow back to us. They're not the ones that will get disbarred or anything. They're not barred. That's on us. We use technology to an unprecedented level, and it's only going to continue. Cloud storage, Zoom meetings, et cetera. So we need to understand how that impacts our ethical duties. So we'll talk quite a bit more about that. Factors to be considered in determining the reasonableness of our efforts in safeguarding this kind of information, and particularly I'm thinking of this in the cyber sort of a context, are these things here: the sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, such as, is our Wi-Fi open or is it encrypted and password protected? The cost of employing additional safeguards. Now, one of the things I teach to my Law 220 students is due process. And this is starting to sound a lot like the factors of the Matthews balancing test, if you're familiar with that. It's kind of the same thing. The cost of employing additional safeguards, the difficulty of implementing those additional safeguards, it's just a big balance. And then an important one is the extent to which the safeguards adversely affect our ability to represent our clients. So we'll come back to that one, but this isn't an exhaustive list. So just be sure that we're considering all of our clients' information and these factors to determine how to best maintain our ethical responsibility of confidentiality. Now, a client can ask us, a client can require us to implement special security measures, even if they're not required by this rule or by any state rules. Or they can give informed consent for us to forego security measures that would otherwise be required by this rule. So keep that in mind. All right, so how should this duty be applied to client communications remotely via Zoom? And is it okay to communicate on open Wi-Fi? Big room, people are far away. I won't make anyone shout anything out, but does anyone have thoughts they want to shout out? Has to be louder than those jets that fly over, though. Is Zoom okay? Has anyone used Zoom to communicate with a client? Seen a lot of yeses on that one, so Zoom is probably okay. What about using open Wi-Fi? Okay, I'm not going to ask who's done that. I'm worried of the response I might get. But we travel so much and we use these kinds of platforms to communicate. Nobody picks up a landline phone anymore. So we probably do most of our communication with clients through electronic means. But regardless of the type of platform, we still have that duty to take reasonable measures. So using Zoom as the example, we all heard of the Zoom bombings, right? When someone would jump onto a Zoom meeting uninvited. Are we protecting against that? You see, Zoom implemented a bunch of, this is no federal endorsement of Zoom. It's just the easy one to talk about. Zoom implemented a bunch of safety features. So when someone tries to get in, you can make them wait in a lobby until you as the administrator admit them. You can password protect your Zoom meetings. But can those be turned off? Yeah, they can. And what's the default setting? If you're not sure, it might be a good idea to look into it. Because while Zoom provides various ways to help keep our communications confidential, we're the ones that need to make sure that those settings are turned on, that those methods are actually being implemented. And that's our duty. That's taking reasonable measures to safeguard our confidentiality with our client. So we have to understand those settings, make sure they're being properly maintained. If we don't really understand Zoom, we need to find a paralegal or someone who can help us to figure it out or take some kind of training to make sure that we're not leaving loopholes. Now, a little bit of an aside, is it ethically okay to attend a meeting with the judge by Zoom with a cat filter on your face? Nobody knows? Yes. Okay. Thank you. I didn't know either. Love that one. Love that one. So one more thing to be aware of, though, when using these kinds of methods, is anybody else in the room with you? Now, when we're sitting down with the client, that's usually easy to think about, but it could be that depending on where you are, you might decide or receive a call from a client and not really think about who else might be there or who else might be able to hear. Am I in a place where the sound is blocked off? Am I in my office? Am I somewhere else where it looks like there's no one around, but the walls are really thin? And that's a little easier to police on your own end. But what about on your client's end? Is there someone else in the room? You might not be able to see them on the camera. You might not be able to hear them. But if there is someone else there, that might destroy your attorney-client confidentiality. So we need to keep that in mind, and we need to police that to the extent we can. It's not uncommon for someone to want someone else to be there. And I had a lot of experiences. I think a lot of people want their spouse to be there when they're talking to an attorney. But what does that do? We have an attorney-client privilege with the client, but if the spouse is there, that's a third party and it destroys the privilege, even though they have a marital privilege and a spousal privilege. They don't have it when we're there. If we're there, we're a third party and it destroys their privilege. So you can't loop all the privileges together. They're individual privileges. If there's a third person in the room, even if it's a spouse, then that's going to cause problems with confidentiality. So keep those things in mind. What about the open Wi-Fi question? I got a pretty solid answer. No, that's not okay. And I tend to agree with some possible exceptions that would be kind of fringe exceptions. So no, we shouldn't use Starbucks Wi-Fi, open airport Wi-Fi, free McDonald's Wi-Fi, or whatever to conduct confidential communications with our clients. State bars and ethics experts have repeatedly recommended not using those. Information can be accepted and decoded, exposing our confidential communications. And that can lead to malpractice claims. It can lead to increased insurance premiums. And it can also take us a while to discover that we've been hacked or that anything's been intercepted, kind of opening wide the door to how much damage can be done with that. So avoid public Wi-Fi when doing your legal business. Now, caveat, because of course there's an exception to every rule. If you absolutely must communicate with your client and the only option is open Wi-Fi, then that's not going to constitute a breach of your obligations. However, even if that's the case, think about how much you actually need to talk about at that time, because it's going to be more exposed. In fact, you might just assume that somebody is listening in. So maybe just make the bare minimum communications. If it's a last minute plea deal for a, oh yeah. is your duty, then you can still apply a monochrome Wi-Fi find your this very focused destination. The duty then becomes that they tell them about that situation. They have the opportunity to go ahead and say, no, so put that off on that conversation. Yeah, so of course, they can waive all kinds of these protections, right? But they ought to know what they're doing. And it's our duty as a lawyer to inform them, hey, we have some risks here, but here's the situation. Are you okay with this? You know, if you just, I'm going to say shout it out as a figure of speech over the McDonald's Wi-Fi, and then your client's like, whoa, hold on. I didn't know you were on McDonald's Wi-Fi. I would have just, you know, had some other way of doing this. I mean, that's on us, right? That we shouldn't do that. I can't point to a particular paragraph in the explanation that goes there, but my answer is yes. So, yeah. So for example, say there's a last minute plea deal, and for whatever reason, you know, oh, the experts are going to fly out in 2 days, and so we need to know, or whatever. And so you need to communicate with your client, and it has to be in one of these less secure means. You don't have to throw the whole case out there. You don't have to say, hey, we both know you're guilty, just take this thing and run. You told me this and this and this, and therefore this is the better option. Just keep it to a minimum. Just assume that someone is likely listening in, and only do what's absolutely necessary. So in summary, Zoom, Google, like whatever communications mode you may be using, make sure you understand the security options, the security settings, and that you're taking your reasonable measures to safeguard all of the information that you're transacting. Open Wi-Fi, generally don't do it at all unless it's absolutely necessary. All right, remember this rule? Told you I'd come back to it. And now that we're talking about technology, we're going to go ahead and take a look at comment 2. So for purposes of this rule, respect for the rights of third persons, a document or electronic, and this is the rule where someone accidentally sends you something relating to the representation. And so you're supposed to let the attorney know, right? This includes, in addition to paper documents, email and other forms of electronically stored information, including embedded data. So metadata. You have, I'm going to share a story. It's not exactly my story. It's something that happened just before I got there, and I overheard it. But at Lackland, there was a time when some of the redactions that some attorney was doing were done by highlighting in Word, in a Word document, the words that they wanted redacted and making them black, like black highlighter, so you can't see anything but black lines, and then converting it to PDF. You're laughing. Have you experienced this? So what happens when it's in a PDF document and you can see nothing but black? Do you mind? Exactly. I don't know if you could all hear that. I have a microphone, so I'll repeat. If you're using the proper redaction tool within your PDF software, then you can't dig under that redaction and find out what was there. But if you're using some other means like the one I just described, it's easy to strip out the underlying information. In this case, what they discovered was that you could highlight that black part of the PDF. You still couldn't see it, but you could hit copy. You could go into a Word document and paste it, and the words were still there. So no shortcuts. Make sure when you're redacting, you're actually redacting. And also, we're probably all aware, but it's worth stating, documents have metadata. Word documents can tell you who the authors are, how long it's been being edited. It may save comments, it may save revisions, it may save these things automatically. So be sure you strip that out before you send it out, which is, I guess, kind of a tip. We're looking at the other end of this. If someone sends that to you, that metadata counts. So, hypothetical. You open your email, you find you've received a proposed plea agreement from opposing counsel in a big upcoming case. You begin to review it, and halfway through, it occurs to you that because of the way it was saved, you may be able to access the metadata and see the history of the changes within the plea agreement. Since you believe this provides valuable inside information that may help you craft a counteroffer, you begin to mine the metadata. So, do your actions in mining the metadata present any ethical issues? Thoughts? This is that weird rule. This is the one where our obligation is to notify the person. So first, we're going to look at the inadvertence piece of it. There we go. They intentionally sent you this Word document, but they probably didn't intentionally send the metadata. They may not have even known that the metadata was there. And so if it's unintentional, this rule is going to apply and you need to let them know. But if it was not inadvertent, there is no duty. I can't imagine a scenario where someone sends a plea agreement and leaves in metadata so you can see all of the changes and negotiations where that wasn't inadvertent. So you should probably assume it was. But if it wasn't, there's no duty at all. If it is inadvertent, which again, you should probably assume, you have a duty to notify. But does that mean you can't look at the underlying data? Looking around. I kind of hope to see some yeses and some nos. It may depend on your state. So, let's see. Some states are more strict. Some states are less strict, but even in permissive states, you still have to follow Rule 4.4. So at a very minimum, you have to notify. But make sure you check your own state before you, I guess, dig into that data, if you would do it anyway. Maybe you have an obligation to do it if your rules allow it. I don't know. Check your own state. So, a sending lawyer, say you inadvertently sent something, just immediately notify the receiver that the transmission of the metadata was inadvertent, and this may trigger obligations for them, but again, it's going to depend on which state you're in. And check your local state bar opinions for the rules and obligations. And then if you're a receiving lawyer, same thing, check your rules, but when in doubt, notify them. All right. So we're gonna move on to Rule 5.1. And again, we're looking at this primarily in the context of technology, but there's more here than just that. All right. In this rule, partner includes members of the partnership. It includes shareholders in a law firm as well as others. And take a look at comment 2. You have to make reasonable efforts to establish internal policies to make sure that all the lawyers in your firm will conform to the rules of professional conduct. So that includes making sure that they're tech savvy enough to safeguard data. Rule 5.3, the duty to supervise. Again, this is a reasonable effort standard. A lawyer must give such assistance. A lawyer must give their assistants appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to representation of the client, and they should be responsible for their work product. The measures employed in supervising non-lawyers should take account of the fact that they don't have legal training and are not subject to professional discipline. So what makes this rule hard? I've got an answer, but is there any, what makes this rule hard? I've only had one legal career. I don't know what all the rest look like. But man, you're busy so often. It's hard to double check everything. It's hard to look over everything. You want to be able to kind of give an assignment and assume that it's going to be completed properly, right? And we should be able to do that to some extent, but we need to know who we're working with. We need to make sure that they understand the rules, they understand the training, so that when we assign something out, we get a product back, we do whatever it is we're going to do with that product. We just need to remember that we still have these ethical obligations, and we need to make sure that whatever is happening in the background, these ethical obligations are followed. And that can be hard when it's a day-to-day, busy, get the next thing out. But keep in mind, paralegals and non-lawyers haven't gone to law school. They have not taken a PR class. They usually don't sit through these super exciting and riveting briefings. And it's not them who might lose their license, it's us. So it's our responsibility. That's why we get paid the big bucks, right? So we train them thoroughly from square one. We don't assume they have prior knowledge. But of course, we need to recognize no training scheme is perfect. And even if it was, human error is always going to be a part of the equation. So what happens when misconduct does occur? What happens when there's some kind of a breach of confidentiality or something along those lines? Well, a lawyer isn't necessarily going to be punished for it. Of course, if you order it, then it's going to be on you. But if you didn't know that it was happening, then the question becomes, did you ratify the behavior or did you take steps to fix the behavior? If you adopted it as your own, then of course, even after the fact, even if you didn't order it, you saw that something happened. Oh, we've got this problem in our law firm or problem in our office where stuff is not being secured properly. You know what? It's already happened. I'm just going to hope there's no fallout from it. You know, that might be you ratifying what's happened. Instead, take steps to correct what's happened, and then you won't be held in violation of the rules. All right, a big one. This is where all the complaints come from. When there are, not all of them. This is the most common ethical complaint against lawyers, is the duty to communicate. So there's certain things that we have to communicate, and let's make sure we do that. If we get a plea deal and it's like, this is a ridiculous plea deal, first off, there's no way I'm going to advise my client to take this. I'm going to very strongly advise my client not to take this. And second off, my client is smart enough to know that this shouldn't even be considered. We still have an obligation to present it to them. That's one of the things that we're not allowed to cover up. So, make sure that we really understand what our clients are trying to accomplish. Sometimes their goals might be different than ours, different than what we expect them to be. I've never been a victim's counsel, but it could be that a victim of some kind of an assault in the military wants a certain thing, but doesn't know how to get there. And it's not our obligation as a victim's counsel to look after the Air Force best interests or to help the prosecution or to help the defense. It's to help the client determine what it is they really want and how to get to that. So we need to make sure we understand their goals. We may say, a good example we talked about earlier is how much risk do they want to accept? We may say, look, it's worth taking the Article 15 because there's so much risk associated with not taking it. And it's not that big of a deal if we do take it. But if that's not what's in line with our client's goals, then that's not what's going to happen. Sometimes we make decisions, whether it's in litigation, whether it's in the periphery around what's going on. We make decisions regarding our client's best interest, and we need to know what their goals really are. We need to know what it is that they want. We can't do that without communicating. So again, we have busy lives as lawyers. We have a lot of things that we need to do and want to get to, and we maybe even want to take some time off. There's a few of us that enjoy that too. And communication sometimes can be a burden, sometimes not, might depend on the client. But it's something we need to do. We need to understand what their goals are, and we need to make sure that they understand what it is that we're doing and keep them up to date. Sometimes they don't know how to articulate their goal. And so that might take a little extra digging and a little extra communicating with the client. The nice thing, if you're not in the Air Force, is that's billable, right? If you are in the Air Force, it's not, but we still do that. The better you understand their objectives, the better you can communicate and consult them about accomplishing those objectives. So update them, let them know what's going on. Even if the update is just, there's still nothing happening. We're still waiting for opposing counsel to submit this motion and the deadline's a month later. It's not a bad idea to touch base. You make the call every week, however often. It might be as simple as an email. Hey, still in a holding pattern on this. But then, of course, when big things happen, let them know. My experience is primarily in criminal cases, I'll admit that. But we have some number of cases that we're working on, and we've seen this stuff again and again. It's kind of commonplace to us, but not to our clients. To our clients, this is the big thing in their life. This is everything. This determines their entire future. They think about it every night. They're wondering if there's a development in the case and they don't hear about it until the next day, that might be just enough for them to freak out, maybe submit a complaint, maybe fire us, or maybe, I don't know, just go haywire. We need to recognize that legal situations are really close to and really important to any client, and keep the communication free flowing. If your client is asking for information, we can't ghost them. If they're a super needy client, if we're super busy at the time, we've got to do something, even if it's just to let them know that they already have all of the information. And again, this goes back to their entire life is wrapped up in whatever this legal issue is. Now, of course, I'm not speaking from a position of corporate attorneys, and corporations don't necessarily have emotions, but I think it still applies. If they're asking for information, make sure you get it to them, and then let them know when they're asking for something that you can't do. If it's because the rules prohibit it, because maybe it's something that will completely go against their interest and they don't realize that, you can explain that to them. Or maybe it's a problem of capacity or expertise, and you can advise them, look, we need to bring on another lawyer. If you want to do that, here are the costs, here are what I perceive as the benefits. But don't drag them along and say, yeah, we'll see, let them know when it's something that you can do. All right, couple of formal ABA opinions. This is from May 2017. It's a reasonable effort standard. So a lawyer may generally transmit information relating to the representation of a client over the internet without violating the model rules. I think we all know that now. Where the lawyer has undertaken reasonable efforts to prevent inadvertent or unauthorized access. However, a lawyer may be required to take special security precautions to protect against the inadvertent or unauthorized disclosure of client information when required by an agreement with the client or by law, or when the nature of the information requires a higher degree of security. Obviously, some things are confidential, but not a big deal, and some things are confidential and a really big deal. When I was a new lieutenant, we had a case where the defense had asked for some derogatory data on an OSI agent. And so we put in the request, and there was some derogatory data, but it really wasn't relevant. In fact, I guess no one knows the case of the person. It was like an experimentation with marijuana before entering the military. And so I notified the defense that there was some data, but that it wasn't relevant. And this agent, I'm not saying I did this all correctly, but this agent really didn't want this getting out there. And we understand, once information gets out, it tends to spread. And so I knew that this wasn't relevant to the case at all. And I let the defense know we got the result. We're just not sending it because there is some information that's not pertinent to the case. We ended up having this big motion to compel. And if anyone knows Colonel Don Eller, this is before the kinder, gentler Eller. And I'm standing there with the one bar on my shoulder that I just put there. And I tell the judge, it's not relevant to this case. And he says, Lieutenant Bradford, can you stand there and put your career on the line and say that you understand all of these rules of disclosure, you understand your ethical obligations, you understand Brady and Giglio and Jenks, and you're saying that this is not relevant. So if later on appeal or whatever, this gets reviewed and your bar license is at risk, you're saying this isn't relevant to the case. I mean, it was an experimentation with marijuana, but still, I was shaking in my boots or low quarters. And I said, yes. He said, okay. And we continued to litigate the motion. Now, it was all for naught because in the end, the OSI agent and her supervisor were sitting there in the courtroom, and having seen all of that, they said, I guess we don't mind if the judge does an in-camera review. And so we changed our stance and said the judge can do an in-camera review. And he pulled it out, looked at it and shook his head and said, defense, you're not getting it. And then we moved on. And maybe that was just a whole lot for a little. And the OSI agent wasn't my client, so I know this is different, but we do need to recognize that even when it causes difficulty for us, confidentiality belongs to the client. And it's not our place to give that up or necessarily even to convince the client to waive it just for our own benefit. All right. So it's Thursday in the legal office. You sit down with your first legal assistance client, Mr. Smith. And Mr. Smith sits down and asks for help filing a pro se divorce packet. So needing some more fodder for your LAMP awards package, you agree. Late in the day, you're swamped, so you ask your paralegal to assist you in completing the packet. To increase efficiency, you decide to upload the file to Google Docs so you and your paralegal can work on the file simultaneously. Any issues? Any concerns? Aubrey? Yeah. So I don't know about all the firms out there, but now within the Air Force, we have great tools where we can do things and collaborate in ways that are encrypted. And it's fantastic. So we're always looking for a little bit of convenience. We're always looking for a way to be more efficient and to get things done. But we do need to keep in mind, is this encrypted? Is it easy for someone to break into? Is it easy for someone to get the wrong permissions? Could someone with the link access this without a password? So what are some precautions we can take with our client's information to ensure compliance with formal opinion 477, the one that we read earlier? Yeah, thanks. Can I pause you really quick? Raise your hand if you can't hear Mr. Davis, please. Thank you, Jeremy.
That allows us to have that. Can you hear me now? Is everybody, can you hear me, sir? Thank you. And so consequently, what they're saying in the state of Washington, at least the protocol belt and suspenders is to have sort of an independent server that has a couple of different types of authentication methodologies to secure the actual data. And then also for the storage of that data to ensure that you don't have leakage or data loss. They also recommend to go ahead and have a system that backs it up. And so this particular attorney just had kind of on his calendar, like, hey, I back my data up every week or so, every few days, just depending on the size of the files. And that seems to at least answer the mail, but that's in one state only.
So anything that we hear about that can result in data breaches, we should also be thinking, how can we prevent this from happening with us and with our clients' files? We can use antivirus software. We can use encryption, using a VPN instead of just using open Wi-Fi, password protecting your own wireless, and regularly changing your passwords. Don't use the same password all over the place. I didn't adopt early on, but I have found password management software to be really useful. And I feel like I have much stronger passwords than I could have invented on my own. The irony is that so many of the Air Force systems say, oh, you only have like 3 special characters and 5 capitals and 6 lowercase and 4 numbers, and I need there to be like something else. It's difficult, but so do those things. Here's one that I hadn't thought of before. What about training on spear phishing? Because con artists are out there and they figure out ways to get information and to get money, and they're ever adapting and adopting new techniques to defeat whatever defenses we have in place. So what about getting some training on those kinds of things to better be able to fight against them? Oops, I was already ahead, wasn't I? Oh, I guess not. So 40 states have adopted the duty of technology competence. And there's still a lot of movement in states and their ethics requirements. In fact, anyone from New York? Okay, probably already aware of this, but as of July 2023, as of July this year, New York lawyers will have to take at least 1 hour of a cybersecurity course as part of their CLE responsibilities. So technology mandated CLE is catching on, and it's getting more serious. So keep an eye out. All right, back to our scenario. It's been a long Thursday. This will probably be our last one, but it's been a long Thursday, so you decide to head home. As you're driving, you realize that you forgot to finish Mr. Smith's pro se filing. But you're in luck because you emailed the filing to your work account. When you arrive home, you boot up your spouse's laptop and log into your home wireless. You get tired of remembering all those convoluted passwords that your spouse creates, so you set the network as unsecured. You log into your work email and download the file to your desktop. Any issues? Any concerns? Aubrey's nodding. We need another flyover, don't we? Jeremy, could you call in a flyover? Just a last one, a big final boom. All right. I'll make this the final thought. Just keep in mind, attorneys won't be punished for being the victim of a data breach. And we're not gonna have time to go into all the data breach stuff, but that's fine. But we must ensure that we've taken reasonable precautions and that we inform our clients when data is accessed, stolen, or lost. Just like corporations who have similar obligations, not by way of legal ethics, but by way of various laws to notify of data breaches. It can be embarrassing. Depending on the situation, it might even receive some press, but that's kind of a time-sensitive thing. So we need to be sure that if we become aware of a data breach, and it might be a long time later, we need to immediately take the steps, notify the affected parties, and do what we can to minimize that. I don't have a slide of numbers. All right. So any final questions?